MAPFRE Insurance Company.
Good morning. May it please the Court. My name is Juan Montes on behalf of the appellant Margarita Carrasquero. We're here appealing order of dismissing count 2 of the complaint and the order granting the motion to dismiss all counts of the amended complaint and an action that we filed against MAPFRE Insurance Company stemming from its liability to the driver of a vehicle.
Do you wish to reserve some time for rebuttal?
Yes, I apologize. 2 minutes, Your Honor.
Thank you. Go ahead.
On what theory was the driver insured by the insurance company?
Okay. Our position is that as the titled owner of the vehicle, the dealership had the right to insure.
We've already decided this case.
Absolutely. It has nothing to do with the issue of vicarious liability under the Dangerous Instrumentality Doctrine.
What is the liability? We have held that the title holder is not liable.
Correct.
Okay.
But
on what basis? And the only reason that we were involved in this case, and that there was an appeal in the first place, is that the insurance company insured the title holder.
Well,
we held that the title holder was not liable, therefore, obviously, the insurance company is not liable.
That's not what this court held. In fact, the insurance company was not a party.
Do you think I may have better knowledge about what this court held than you?
Well, I was trial counsel and appellate counsel, and I know what the issues were and the issues that were framed, Your Honor, and I have your opinion. The issue had nothing to do with insurance. The insurance company wasn't a party in that case. The insurance company or coverage wasn't an issue in that case.
Back to the original question then. On what theory does the insurance company insure the driver? The policy was taken out by the owner.
The automobile was insured under the policy that was taken out by the titled owner. It was MAPFRE. The driver is an insured under the terms of the policy because the policy provides that an insured includes anyone who's driving the vehicle with the permission of the owner.
But if Ethan's Auto is not liable, then how can its alleged employee, how could Mr. Diaz be liable?
First of all, Mr. Diaz was never found to be an employee per se using that term.
Regardless of whether he's an employee or not, if the company that he's working for that is the insured is not liable, then how could he ever be liable?
Our position is not that Ethan's Auto is liable. This court has already determined under Dangerous Instrumentality Doctrine, and that's a specific doctrine, that he's not liable. The issue here is that Diaz was still found liable. There's a judgment against Diaz, and he's insured under that policy.
Under what theory could he be insured if Ethan Auto is not insured? Well, if they're the insured and they're not liable.
We've alleged in our complaint that there was still a policy that insured the vehicle. Just because there is no liability.
Did you attach the policy?
What is that?
Did you attach
Yes, we
policy?
did.
And what is the language of the policy which insures Mr. Diaz?
Mr. Diaz? Yes, Your Honor. The language of the policy that insures Mr. Diaz is on Section 2, and it says, who is an insured? Subsection 1 says, you for any covered autos, and then subsection 2 says, anyone else while using with your permission a covered auto you own, hire, or borrow.
You meaning the employer?
Well, he wasn't an employer, so I just want to clarify that. But it says you and anyone else driving with the permission.
You is the corporation, correct?
Correct.
So your argument must be that our previous determination of beneficial ownership does not prevent you from raising this issue anew.
It does not. It does not, Your Honor. That case.
And if we determine that that's an incorrect premise, then you lose.
That is correct. But the reason that this court should not determine that this incorrect premise is because the only issue there was whether under the Dangerous Instrumentality Doctrine, whether Ethan's Auto Express is liable. That's it. That was the only issue.
And the reason that we held that it was not liable is that it was not the owner of the vehicle for purposes of the Dangerous Instrumentality Doctrine. Is that not true?
That is correct.
But you're arguing that
owner for the purpose of being insured.
Right.
That has nothing to do with the issue of being insured because there's
why
case law.
Doesn't it?
Because the case law on the issue of insurance says that the insurance coverage could be broader than a party's liability under the law.
Do you have any policy, any case that says even though you are not liable and you are not the owner, you are still somebody else is driving with your permission, and therefore that person is liable and an insurance company is liable.
Well, Judge, I think you have to look at just basic contract law.
Do you have any case?
Well, the closest case to that is the Creative Hospitality Ventures versus U.S. Liability Company case, which is a federal case 655 Federal Supplement 2nd 1316 from the Southern District. That said, and this is consistent with Florida law. The coverage under policy and duty to indemnify may be broader than liability under the law.
Well, no question about that.
The issue in the first case was only liability under the law, was not coverage.
No question about that. But we have held that the employer is not the owner of this car.
That is not for purposes of the dangerous instrumentality doctrine. They still had an insurable interest in the car. They insured the car. They're not supposed to.
You can't create an insurable interest by saying they had an insurance policy and then say because they had an insurance policy they have an insurance interest.
They had legal title to the car.
Of course.
And with legal title to the car, they have an insurable interest. In the case out of the Fifth that just came out, the Bowen case, which is cited there, which obviously
the Fifth District case you're speaking of?
That's correct. Which obviously is in
conflict
with
There's a lot of discussion about this case in that case, isn't there?
But there is. And the Fifth District case would be in conflict with the original Carrasquero opinion. That's been certified and accepted by the Florida Supreme Court. But irrespective of that, the issue there is that there is still, as bare legal title, there's still a species of ownership. That means there's an insurable interest. A person can get insurance because they have bare legal title. In fact, Mr. Diaz could not insure this car because he neither had title nor registration to a vehicle, and in Florida it's required for an individual to have insurance in order to drive the car.
You missed the entire point of the first case.
The point of the first case was simply the dangerous instrumentality. The insurance company was not a party. Issue of coverage was not an issue in that case. It was simply liability under dangerous instrumentality doctrine. You could have an insurance policy that provides coverage for certain things and other things, even though the named insured may not have liability under the law.
Okay, thank you.
And the position here is that the policy covers anyone driving with the permission of the owner. Doesn't define owner, doesn't say that owner means legal title or beneficial title. And in fact, Florida statute says that an owner is a person who has title. And that's Florida law. That's a statute. So if the Florida statute says that the legal owner is the titled owner.
Once this court has found that the insured had no liability, it's very difficult to argue that someone who's driving the insured's vehicle would be covered by that insurance policy. And that's the real issue.
But, Your Honor, that whole solely goes to the issue of contract law. You have to look at the policy.
That's not the holding that we have to deal with. The holding says as a matter of law, notwithstanding that it was the record title holder, it was not the beneficial owner of the truck involved and subject to accident, and thus was not liable for its negligent operation, period. It doesn't limit this to the dangerous instrumentality issue.
That was the issue before this court. That could be the only issue before this court. There was no issue of insurance coverage. That wasn't litigated and couldn't have been litigated at that time, which is why the res judicata and collateral estoppel don't apply here. How can you litigate a contract issue that wasn't before this court? It was simply whether or not, under the dangerous instrumentality doctrine, Ethan's auto.
But the contract, which is the insurance policy, the words of the contract incorporate what is true as a matter of law. If we have said that they are not the owner, you can't say that they are the owner under the policy.
That is incorrect, Your Honor, because you could have broader coverage than liability under the law. And the fact that the policy doesn't define owner as legal title or beneficial title, having beneficial title is a problem, it's an ambiguity. Many policies use the word ownership and define it, in this case law that we cited in the brief, as the person that has legal title, bare legal title, defines ownership in a policy. In fact, I think it was the 4th DCA that found that even the words legal owner were ambiguous.
I think we understand the argument, and I will allow you 2 minutes to rebuttal, although you've already used them up.
Thank you.
May it please the Court, Barry Davis and Daniela Friedman of Thornton Davison Fine for the appellee. Judge Schwartz, writing for the unanimous court in Carrasquero versus Ethan's Auto Express in 2007, established the law of this case, as the court recognized. And in that decision, of course, what was found very specifically was that The undisputed facts were that the co-defendant driver, Abel Diaz, who worked for Ethans, bought the car for his individual use from Randall Auto Finance, Inc., paid the entire $4,000 purchase price, and possessed, maintained, and controlled the use of the vehicle himself. On the other hand, the owners of Ethans did not even or ever so much as see the truck and agreed to take title in its name only as a tax delay inconvenience to Diaz. Under these circumstances, Ethans had no liability under the dangerous instrumentality doctrine.
But doesn't this mean that the vehicle then was not insured, period?
Yes, because it wasn't owned by Ethans. And there is a case directly on point on that issue as well that was completely ignored in the appellant's brief and in their reply brief. In that case, is State Farm Mutual Automobile Insurance Company versus Hartzog, decided in the 4th District. And in that particular case, the court held that beneficial ownership is determined by the overt acts of the buyer and seller at the time of the agreement and thereafter. The name on the title is not the litmus test for determining who owns the vehicle for insurance purposes.
Hartzog is sort of the flip side of this case, right? Because there the beneficial owner was seeking coverage.
Correct.
And they held name on the title is not the litmus test.
Exactly right. But they specifically addressed the issue of coverage, so that the reason that there's collateral estoppel in this case is because it's law of the case on the issue of beneficial ownership. And beneficial ownership is the issue that decides both liability as well as coverage. And there's privity between the insurer and the insured on that issue, because if it had been determined in the underlying case that Ethans was the beneficial owner, then the insurance policy would have been triggered. But the opposite was determined, and the opposite was law of the case that there is no beneficial ownership. They don't own, they're not liable because they don't own the vehicle. If they don't own the vehicle,
didn't plain insure somebody else's vehicle. That's what
except
it amounts to. They
correct.
just didn't. The insurance policy, which is paid for and issued to the employer, does not cover a vehicle that they didn't own or had anything to do with, for purposes of liability for an accident.
That's exactly right. And insurers, for public policy reason, like to know who they're insuring because they want to have the benefit, and that's why owner is an equitable issue, as the court found, and because insurance companies want to know that whoever they're insuring is the one who has control and equitable use of the vehicle, so they protect that asset. They, in fact, even find out who you are. Perhaps you get a discount because of your driving record. So there's a public policy reason as well as to why the word owner would be.
As a matter of fact, since they didn't own the car, they had no right to let anybody else use it.
Correct.
And there's no definition of owner in this policy, unlike the 4th DCA case that they rely upon, where owner is actually defined as title holder.
Exactly. If they wanted to change the definition of owner, making it something other than what's equitable and accepted in the industry, then they could have done that in the policy, but simply because there's no definition doesn't make it ambiguous. And in fact, there was a case that was cited by the Palmer case, the Pompano Beach versus Motor Company case cited on page 12 of the reply brief. The appellant misstates the holding in that case, and they said that the court found that the word legal owner was ambiguous. In fact, the case found exactly the opposite. The case specifically held just the opposite and supports our position. They said in that particular case they had to define the definition of legal owner, and in that case it wasn't defined in the policy, and they went to the dictionary definition of it and found that it meant equitable ownership, just like in our case. So it did not say that it's ambiguous. They did the exact same thing that we did in the case, is go to the dictionary definition and the accepted use of the word owner in the industry and in the definition. So that case holds specifically the opposite. It said when a term has not been defined by an insurance policy, its common definition should prevail. And in fact, they found that there was no coverage. So unlike what the appellant said on page 12 of their reply brief, it certainly did not hold anything that the word owner is ambiguous with respect to an insurance policy. There's no provision in the policy that provides coverage for Diaz. The only coverage is for a covered auto. And it's only a covered auto if it's owned by Ethans. And that's already been found to be law of the case, and for that reason we would request that the court affirm the trial court below.
Thank you. And I will give you 2 minutes for rebuttal.
Counsel said that the parties were in privity below. The parties could not have been in privity because the issue here is Diaz, whether Diaz has a right under this policy, not whether Ethan's Auto. Diaz was not represented by the insurance company. The insurance company didn't defend an insurance company, pretty much laid them out in the wind, even though at the time we said that the vehicle was owned by Ethan's and that Diaz was a permissive driver. So there could be no privity under those circumstances. That's why Diaz has a right to bring this cause of action. That's why, because we're bringing it as an assignee as well as a third party, and why there is no res judicata here, because these issues were not litigated and the state parties were not involved. The ownership issue, the policy doesn't define ownership. I cited 2 cases, the R.S. Evans case out of the 2nd, and the Anderson versus Aetna out of the 4th, and the Birmingham versus Rosado out of the 5th, cases where the ownership in the policy was defined as a titled owner. So what is owner? Titled owner, beneficial owner for purposes of insurance policy. It's not defined, it's ambiguous. But Florida statute defines it under 324.021 subsection 9b3 as the person who holds legal title of a motor vehicle. And they're the person that's supposed to insure it. So their policy would not even comport with the statutory definition of ownership.
How do you distinguish the Hartzog case?
The Hartzog case is the Hartzog case is really not the issue here, because this is an issue of coverage. Has nothing to do, and it's coverage for Mr. Diaz.
Didn't that case discuss coverage?
But not in the same scenario as we have here. We have this here. The issue is coverage to.
Of course, it's not the same scenario, but it's exactly the same reasoning.
But we have a policy of insurance here that does not define the word owner. It leaves it up to the insurance company to determine it. How could anybody other than Ethan's have insured this vehicle, which must be insured under Florida law, in order for it to even be sold?
You know, the driver and the actual owner could have insured it.
The driver and the actual owner cannot insure it because they don't have title to the vehicle. The only person.
So what we did in the previous case is a total nullity.
Well, frankly, I believe that it was wrongly decided. I think the 5th DCA would probably agree.
It's okay.
But irrespective, it's not, because the issue there was simply dangerous instrumentality. That case is not really defining issues here.
You thought it was wrongly decided on the day that it came out.
If that's the question, honestly, I do. But irrespective of the decision, it's
and
not
you know
the
what
issue in this
you can
case.
get with that idea and a quarter?
Well, Your Honor, it's not that idea. The idea is that the issues here and the parties here are different. These are contractual issues that were dismissed on a motion to dismiss, not even a summary judgment. And respectfully, we believe that there's a policy in place that provided coverage to Mr. Diaz, and that the trial court should be reversed.
Thank you very much.